Good afternoon, everybody. How are you? I hope you're really well, enjoying the start of potentially spring happening. I know it's been a bit miserable at the moment, but we are here and we're back with the Essential series, and we are so excited to have Lara Barton and Esme Sheridan of Hunter's Law to navigate the law for vulnerable individuals. So these are two legal experts who work daily at the intersection of capacity, safeguarding, and family dynamics and long-term protection. We're going to be finding out all of the different ways that they are able to support and to share their knowledge on what to do for certain circumstances. So let me just let the ladies in now. Hi, Lara. Hi, Esme. How are you?
Hello. Hi. All good, thank you.
Good, good. Lovely to have you with us, and we're really excited about this conversation. Before we get started, please could you just share who you are and what you do?
Sure. I'm Lara Barton. I'm a partner at Hunters. I've been at Hunters for quite a long time now, I think since 2004. I'm a private client lawyer and I do a fairly broad spread of work, but quite a lot of it does touch on capacity issues. I do quite a lot of older client work, a bit of court protection. So yeah, the subject today is quite relevant to my practice.
I'm Esme Sheridan and I'm an associate at Hunters Law, and I've worked at Hunters coming up to 4 years this year. I'm a private client lawyer and I work alongside Lara in her team, dealing with various private client matters, from dealing with vulnerable individuals that might be elderly or younger people, including wills, probate, court protection work.
Brilliant. Thank you, ladies. Well, I think before we dive into specifics, it would be quite helpful for us to share how the law defines vulnerability in the context that we're describing today, and then what kind of situations you're most frequently seeing within your practice that fall under this category.
Yes, so vulnerability is a central part of private client work, and there isn't one single definition, but we do use definitions and guidance from, for example, the Mental Capacity Act and the Court Protection and Care Act. And then it covers any factor affecting decision-making, understanding, or self-protection. For example, individuals may have dementia or cognitive decline, they may have addiction issues, suffer from financial abuse or undue influence, bereavement or major life changes, mental health issues, loneliness or isolation, and are also facing digital risks and scams. So we have to, as a firm, use risk-based assessments on a case-by-case basis, and there isn't really one definition, it's just assessing the situation at hand.
Yeah, I think that, yeah. Lara, do you have anything
to
add?
I was just going to add, in terms of the sort of situations that we're seeing quite often in practice, I think for a while now, people have been quite mindful that we have an aging demographic. There's a lot, and so that's something that comes across our desks a lot, capacity issues associated with dementia. But also there's a lot more awareness around sort of situational vulnerability. So as we go through life, whether perhaps somebody is quite young and financially inexperienced, if they come into money, they might be quite vulnerable in that context. Someone could be going through a relationship breakdown or a divorce. Again, that can create vulnerability, particularly in a sort of relationship where perhaps a bit old-fashioned. One person is taking all the decisions, the other is sort of reliant on that person, and out of that, we sometimes see coercive behaviour. And then, of course, there's things like addiction that creates vulnerability. Bereavement is another obvious one. Whatever age you might be, if you're bereaved, that can put you in a very vulnerable position for certainly for initial period. So we encounter all those kind of situations in terms of vulnerability.
Yeah, and I think that that's really helpful for everybody to know, is actually there is a spectrum there. There isn't one definition, and so it really comes down to having awareness of circumstances, and understanding what a client or an individual is going through, which sometimes takes a little bit of digging, because they might not actually be forthcoming over what circumstances they're actually encountering. And I guess one of the most challenging areas for families is mental capacity. Some individuals don't want to accept perhaps that they have dementia. They might keep it quiet from their family because of, they don't want to upset them or any of these sort of things. But could you walk us through the actual key principles under the Mental Capacity Act and how you approach capacity concerns when they arise during something like maybe will making or financial decisions?
So in terms of the Mental Capacity Act, which I'm going to refer to as the MCA, and there are 5 statutory principles which guide us helping with capacity decisions. Firstly, there is a presumption of capacity. So no proof is required unless there's a reason to doubt someone's capacity. Age, diagnosis, or unusual decisions don't remove capacity in itself. Secondly, use support to help individuals decide. So take reasonable steps to help those individuals make decisions. For example, if someone requires shorter meetings with breaks and intervals, or information to be broken down in a different way. Unwise decisions, that doesn't mean that they don't have capacity. When someone is allowed to make an unwise decision, but it can be an example of maybe considering vulnerabilities. And then you are supposed to act in their best interests. So consider an individual's wishes, consult others, avoid discrimination. And lastly, you are supposed to choose the least restrictive option. So intervene as little as you can and tailor their support to assist them make decisions.
Which is a skill in its own right.
Yes. Exactly. And I would say in practice, making sure that you can speak to the client by themselves to ensure you can spot any vulnerabilities will then help you can assist them to make decisions if they do have capacity to do so.
Yeah. And I suppose a lot of that is a judgment call that you would have to do. So I don't know, Lara, if you've got any, comments to make on that.
Yeah, so I think, as you sort of alluded to earlier, Lottie, I think you need an awareness that vulnerability and financial abuse, they can kind of crop out of the woodwork. And so from a professional's point of view, we try to look for changes in behaviour. From our side of the desk, that might be, an obvious one might be a sudden change of instruction for someone's will. You might have been acting for them for years, for decades, and then suddenly they have a complete change of heart, and you're thinking, and if that happens at a time when you think, they might be vulnerable because they're quite old or because something's happened in their lives, then that is definitely a red flag. And so that means we should be probing a bit further. I think from anybody's point of view, just any sort of change in behaviour, any change of thinking that seems a bit odd. I think an obvious one is when people who are vulnerable strike up a sort of a relationship with somebody new, particularly where there's a relationship of dependency. And what we quite often see is vulnerable people, particularly older vulnerable people, becoming dependent on somebody like a carer, or, I'm sad to say it, quite often it's a younger person who sort of wheedles their way into their lives almost. And then financial abuse can occur from there. And it might not be sudden. It could be very gradual and therefore not that obvious. And so again, sometimes what we see is it's after someone's died, you realise what's been going on, because then the financial records are looked at and the family suddenly realise, and sort of the full picture is revealed. But yeah, so I think in terms of advice about what to look out for, changes in behaviour, new relationships which just don't seem quite normal. Again, heavy dependency on somebody. Those are all red flags.
Yeah, and that's terrifying, isn't it? That link between dependency and deception, and how insidious it can be with some of these relationships, where they might have a carer role, but actually there is malintent behind it, which again, even if you are a professional and you have witnessed it, it will all sort of appear or manifest in different ways. So, those are tricky signs to, you guys are good at spotting those red flags, but then I suppose, how do you actually act on it without disrupting too much? I think that's a tricky thing.
I think just to mention, I think another area we quite often see is with lasting powers of attorney, quite often with children. I mean, not often, but we do see this. Children are appointed as attorneys for their parents. Again, people are living a lot longer, and there's a lot of financial, economic pressure. We're generally not in a brilliant place in terms of our economy. They're fine for some people, but there are a lot of people who are really struggling. And so we do see and hear about people in that attorney role. Again, it's not dramatic, it's not sudden, but starting to utilise funds in a way that they shouldn't, their parents' funds. And again, it can quite often be much later in the day, possibly post-death, that people realise that actually they've been squirreling away funds for their own benefit rather than, doing what they should have been doing. So that can create conflict and, unpleasantness at a pretty dire time.
Yeah, it's terrifying. And I guess, we're talking about undue influence and financial abuse and how it is becoming more prevalent, and whether that is a sign of, the economic times or, different circumstances or just the way the humans are behaving. What indicators do you tend to look for? I know you've mentioned some, but, how can advisors or family members spot those early on? So, whether it is undue influence or financial abuse.
I think knowing your clients, knowing your family, communication, the principles are kind of the same. So for us as professionals, the knowing your clients, checking in with them, particularly when there's a change of circumstance, something happens, just being alive to the possibility. I think from a professional's point of view, there's a lot more education going on around it now. There's a lot more. There's a much greater onus on us to understand and be aware and find out. But equally, I think if we're talking about a personal relationship, the same sort of principles apply. It's checking in with people. It's trying to keep on top of any changes that are happening, making sure that different people are trying to communicate. So where someone has, they have people looking out for them, like in perhaps a medical role or advisory role, then there's family members. The more people communicate, I think the better. Certainly we see that.
Definitely. And I guess it's really useful for us to possibly share what a lasting power of attorney actually is, and what that actually covers for individuals and their families.
So a lasting power of attorney, you can appoint individuals known as attorneys in your lifetime to assist you with your property and financial affairs. So that would include your bank accounts, your properties, any sort of fund where you appoint attorneys to assist with health and welfare decisions, for example, where you live, your care, and medical decisions when you do not have the capacity to make those decisions. So, and those can only be put in place when the individual has capacity to do so. So we always do advise clients that get those in place if you can while you have capacity. And, there's also periods of time where capacity may fluctuate or it's potentially you're losing it. So you would have to get a capacity assessment so that you can ensure someone has capacity to put those LPAs in place. Should a lot of individuals, or not a lot, but some find they don't trust anyone to do that. So it's about then helping them understand the powers within LPAs and what they can do. And if you cannot get LPAs in place and you've lost capacity, then there is a deputyship option. But this is long, to be honest. It takes a while to apply to the Court of Protection, and it's also quite costly. And usually the Court of Protection doesn't allow, they're quite hesitant to allow health and welfare deputies. So if you do want someone to assist with that, they may not allow it. So we do always advise it's best to think about these things as soon as possible while you have capacity to avoid those sort of difficulties for you or your family further down the line.
Yeah, and I think it's something that young, fit and healthy people also don't think about. But if you think, it's not just mental decline, it could be if you're in an accident or something like that as well. And I think people forget that, and it is almost an insurance policy for your care moving forwards, to having people that are going to actually be looking after you. Because what happens, so you're saying about the deputyship, sorry, this is a bit of a curveball, this is just like me being interested in it. So what happens if you don't have an LPA or, and the deputyship, like, and maybe you don't have like a next of kin or anything like that? What would happen to you, say, if you then were in the circumstance where you didn't have any capacity? I don't know if that is a...
So then I think you're in that sort of grey area. And so if you're talking about finances, then your assets effectively untouchable. So somebody will have to make an application to the Court of Protection. And as Esme was alluding to, an application can either be made for a deputy to be appointed, in which case they have overall control over the person's finances, and likewise with health and welfare, you can have the same thing. But with the welfare, the court doesn't particularly like granting a single person complete authority in relation to health and care, so they're more likely to make a single order. And I think on the health and care side, if there's no deputy, no order's been made, or no one's taken that step yet, and there's no LPA, you're probably in a situation where the medics, social services will operate on what we call a best interest basis. So they will make best interest decisions, and that sort of covers that grey area. So they will all gather together and they will consult with any family, and then they will make what they consider to be the best decision, the best interest, the decision that is in the best interest of the individual.
Gosh, so yeah, it's
it's sort of a temporary arrangement, really. And I think the best, for me, I always think the best focus for a client or anybody when talking about lasting powers of attorney is to think, what will happen if I don't get around to doing this? And I have an accident, I'm incapacitated. You might be 35, you get hit by a bus, or you fall off your bike. You've got maybe you might be in a coma for a month. What's going to happen? You could be in the middle of selling a house or whatever it is. And in that situation, if you haven't got an LPA in place, your family will have to make an application to the Court of Protection. And our experience is that they will only allow emergency applications in really, really dire situations. So it kind of has to be almost like a life and death situation, doesn't it? So I think with that focus in mind, or that reality, it does help people focus.
Yeah, and it's a sort of, why not? Why would you not? And a lot of the time, it's the same with wills. People just don't get round to it, or they don't want to face their immortality.
It's a really common human condition.
Yeah. But this is why conversations like this are so important, because there are risks in life, and it's better that you have a handle on those risks, and you've got a plan for risks, I think.
Yeah.
And then you can take...
Even if it's not perfect, even if you don't feel like you've created the perfect setup, I think as long as you feel it's broadly good, then it's better to have it in place than not. Yeah.
Definitely. And I guess, that there is possibly, responsibilities that attorneys sometimes overlook. What might those look like, and how can misuse be prevented? I know we mentioned about, possibly LPAs, the children may be siphoning off some funds that are meant to go to the parents. What other examples or circumstances have you witnessed?
So one example would be not acting in the best interests of the individual. So the attorneys might make decisions which which are just more convenient for them, or preserve family harmony, when in fact that's not the best interest decision for the individual themselves. Another example would be not keeping finances separate, and we would say avoid using joint accounts, establish clear boundaries, and just borrowing money isn't advised, and mixing assets. So keep things separate if you're an attorney and you're assisting someone with their finances. And that then leads to maintaining proper records. So you've got receipts, clear accounts, so that if anything does need to be checked in the future, you have a clear record of everything that's been spent and paid for. And then another example would be following strict gifting rules. So when you're using an LPA, attorneys are only supposed to make very small gifts, ones that potentially the individual would have made, small birthday gifts and things like that. But obviously making huge gifts of property or things, large cash sums, they're not allowed to do that. So you would have to apply to the court for an application to do so. So often that's misunderstood and gifts are made when they shouldn't be. Avoiding conflicts of interest is another example. For example, an attorney buying the individual's property at a lower price potentially, that's obviously a conflict. Or an attorney paying themselves for care without authority. So, and then the last thing I would say, people sometimes don't consult the donor, so that's the individual. They should consult them where they can, because if they have capacity, they should be speaking with them.
Or they might have moments of lucidity.
Exactly.
It's not a static thing, it can fluctuate.
Yeah, and again, that's where relationships are so important in these kind of circumstances, and also having a professional to oversee some of these processes, because families don't always function effectively when they're left to their own devices, as we all know, which is why we all have jobs. So talking about risk again, so when a beneficiary or a donor, as you mentioned, is vulnerable or at risk, estate planning needs become far more nuanced. What structures, maybe discretionary or disabled person's trust, work best, and how do you balance protection with flexibility?
So the trust you mentioned, the discretionary trust and the disabled person's trust, those are the two obvious sort of strategies. And the hallmarks, and most people might know this, but the hallmarks of a discretionary trust are that the trustees hold the assets for a class of potential beneficiaries. So it can't just be one person. They have to have a group of people over which, or in relation to whom, they can exercise their discretion to allow them to benefit, and they have discretion as to how they can benefit. And in terms of tax, the discretionary trusts get taxed sort of on an ongoing basis in terms of inheritance tax. So there are exit charges when capital is taken out. There are decennial charges on each 10-year anniversary of the trust, but those charges tend to be fairly low, maximum 6% on a 10-year charge. And that's only if the value in the trust is over the normal right band. The trustees are taxed at high rates, and then if you compare that with a disabled person's trust, that is a trust that's set up specifically for an individual, a disabled individual. The tax treatment is much more favourable during their lifetime. You don't have any of these sort of ongoing charges. The income tax treatment is more favourable. But the difference with the discretionary trust is that on the disabled person's death, the whole fund will be subject to inheritance tax, whereas with the discretionary trust, that doesn't happen because it doesn't fall into any particular person's estate. So I think that they're quite different beasts, and you need to look at them together when you have a client or a family where there's a disabled person. and weigh up all the sort of the different family dynamic, the different financial situation. So, for example, if you've got a family where there are quite a few children, one of whom is disabled, and the parents want to benefit potentially not just the disabled person, but maybe ultimately their other children, a discretionary trust might be suitable. And that would be particularly so actually if the level of the fund was within the sort of nil rate band, because then you're not going to have these ongoing charges. And at the end of the day, when the disabled person dies, if there's any funds left in there, they won't be subject to inheritance tax, and they could be distributed amongst the other siblings. Whereas perhaps, say, for example, there's a family where there's just one child who's disabled. The parents aren't terribly concerned about tax at the end of the day because there's nobody else they especially want to benefit. Then a disabled person's trust could be much better, because obviously during the lifetime of the disabled person, the tax will be much better.
That's really good to know, actually.
Yeah, I think really it's you just every time we get a new instruction, it's really just a fact-finding exercise and discussing the options with the client, and just working out what is best for them ultimately, and what the tax situation looks like.
Yeah, definitely. And I guess, most of this is about handling, harmony as much as possible. So what happens in terms of this planning when you're dealing with a client where there is existing family conflict or fractured relationships? It's over to you to try and navigate that, I suppose, for their best interests.
Yeah, sadly, it happens all too often. So I think the first thing is, who's your client? Who are you looking out for, or who should you be looking out for? Yeah. That's probably the most important point. I think sometimes people get a bit confused. And if actually the person at the center of this is the disabled person, the focus should be on them. What is best for them? And you have to sort of try and cut out some of the noise of the conflict, and not cut it out, but you have to do your best to diffuse it. Because no one wants to end up in a situation where no one can make a decision, and you have to get the courts involved. And I think really it's all quite basic stuff: dialogue, communication. Trying to encourage people to look at the end point. What's the best outcome of this? What's in the best interest of the individual? And no one wants to run up vast sums in legal fees. That's another great focus. It's a pretty sad day when things are left to the lawyers to fight and it just works. So that for us, that is a really bad result.
Well, definitely. And I suppose as well, the courts are probably not very amused when things land on their desk as well, when they're seeing that families can't solve these disputes together. But are there any particular trends or cases that you're seeing that do end up at court? So I don't know whether it's a will challenge or allegations or just disputes. What have you seen?
So there's definitely a surge in will challenges surrounding undue influence, and I think more cases are succeeding due to, as you say, fragmented families and more digital evidence that we have available now than we didn't previously, and also relationships such as predatory carers. You're seeing a lot of those sort of relationships appear, and then claims are made. So the courts is showing zero tolerance to attorney misconduct, which we discussed earlier. For example, misuse of money, gifting money they shouldn't have. So those are very prevalent cases. There's also greater focus on predatory marriages, which is something the Law Commission has suggested is changed. So that's ongoing. And there's also more disputes over capacity assessments and professional conduct. So there are high expectations on professionals to make sure things are documented, and meetings and advice given and instructions, so that later on down the line, should any claims be made, that evidence is there to be reviewed.
Yeah, that's really helpful. Thank you. Have you got any comments on that, Lara?
Not really. I think Esme's sort of summed it up fairly well.
Yeah. Well, I think, you know, you touched on there. It's about the advisors and for them to have awareness. But for anyone who is watching this, or they're watching it on the replay, who are working across the private wealth space, what does best practice look like when they're working with individuals who may be deemed as vulnerable?
So I think I mentioned earlier that I think there's probably now a much greater onus on professionals to be alive with vulnerability. So that awareness is critical, and to create the awareness, I guess we need to make sure that we are training people, understanding what the sort of full scope of vulnerability could look like, knowing your clients, accommodating whatever their needs might be. So an obvious one is if we're seeing somebody who's unwell, whether they're young or old, or we're seeing someone who is old and perhaps their memory is not so good, we go out of our way to make sure we see them in a setting and at a time that suits them best, when we think that their capacity is at its greatest. And also, you don't want to go and talk to somebody about professional things, about money, about law, whatever, when someone's feeling tired and not very well. So I think adaptability is quite important. Certainly, I think solicitors, we have an obligation to have a policy for vulnerable clients. So we make sure our staff are aware of that, and that really just covers quite obvious things. It's about, on your systems, if you know somebody has recently been diagnosed with dementia, it may not be obvious because people will do everything to mask it in the initial, or quite often it's common that people will do everything they can to mask it in the initial stages. So, if your staff are aware that this person does have a diagnosis, or it seems likely they might do, it might end up that way, then I think that's very important. And again, that sort of ability to be a bit adaptable, to go out of your way to try and help people to function and do whatever they've got to do, whether that's make decisions or make decisions about, wills, whatever it might be.
Yeah. I think
that's just to continue on that.
Yeah.
I was just going to say, I think if then that awareness, if people are concerned that maybe things are really getting worse, or there is a capacity issue, what is the next step? And for us, that would be to really to get a formal assessment done, a medical assessment, to know whether we can continue to act for that client.
Is that something that is sort of a requirement then? Because perhaps if you guys notice behaviours or something that would mean that their capacity is reducing, and maybe the family doesn't know, do you have to bring that up and say, we actually need to investigate this further, or we can't act with you?
If we take instructions of someone who is subsequently deemed with lack capacity, we'll be in pretty hot water with our regulator, and also the family. You could be at risk of litigation, and I think the same will apply across different professions. Their regulators will be quite hot on this. So it's really having that understanding that at some point you might need to have that very uncomfortable conversation with the individual, with the family, and I mean, I've had to do this quite a lot, and saying we are very tight, we have to ask you to do this, and that kind of softens it a little bit. But yeah, it's not easy, but I think you can never be too safe.
No, definitely. And I guess if we look ahead, are there any changes or challenges that you particularly, might anticipate in safeguarding capacity or vulnerability work over the next 5 years? I know there's a lot of sort of law changes or need for change in different areas of family and private client law, but is there anything in your space that you're seeing that you think might be adapted or changed?
As we've been discussing, I think one of the main changes is more complex capacity that's coming about. We need to be aware of and spotting that, and the different types of vulnerability. And then secondly, I would say digital vulnerability. There's a growing risk that people are, they're going to be subject to fraud, sophisticated fraud in particular, and potentially crypto-related scams. So there's things we need to be aware of that are on the rise. And then lastly, I'd probably say rising expectations of us as professionals, higher standards to ensure we're spotting these vulnerabilities and ensuring people are able to make these decisions and supporting them to make those decisions.
Yeah, I think that's so important as well. It's growing with the times, as most things are, and there are some horrific scams out there, and they can affect anyone, whether or not you've got mental capacity. So it is terrifying, and that's where that awareness and education piece really comes into play. But especially for vulnerable clients who may be at greater risk, whether right as you said at the beginning, if they're lonely. It's very easy for somebody to walk in and cure that loneliness for a price, which is terrifying. But I guess as we wind down this conversation, where there's been so many amazing things that you've shared, thank you. Is there one piece of guidance that you would give to anybody listening to this session to take away?
So my one bit of guidance would be really just be aware. Keep your ears open and communicate. I think the more complex cases we've seen, and I'm sure this applies across people working in the wealth area, is if there is a sort of situation that doesn't look quite right, you get a little red flag and you can't quite pinpoint why you have got a red flag. Talk to other people. If there are other advisors, talk to them. I mean, I found that we've had some pretty tricky, complex cases here at Hunters, and when there have been other professionals involved, whether those are medics, whether they're accountants, investment managers, whoever, the more that everyone is talking to each other, the easier it is to find a resolution. Humans are generally fundamentally good people, and if you get them working together, a solution can usually be found.
Yeah, I love that. And, and it seems so easy in principle as well, like collaborate and do it for the best interest of your client.
Collaborate, exactly. If people are all pulling in different directions, it's a disaster. And that's often when conflict arises.
Yeah. And listening to each other, because I think often, when conflict starts to happen, there might be an imbalance in power dynamics as well. So,
and there's a lot to be learned from each other as well. I think, however sort of long in the tooth you might be, and you think you've got all the experience in the world, I think everyone has still got more to learn, particularly in this life where things are so fast paced and we've got this whole digital thing going on and AI, it is quite daunting.
Yeah, I completely agree. Is there anything from you, Esme, that you'd like to share?
No, I agree with Lara.
Just keep your antenna up and your ears open.
Yeah.
I love that. Well, thank you so much for sharing that on what can be a difficult topic, but actually it affects all of us in so many different ways. Even if we don't expect it to right now, this is something, whether it's aging parents, whether it is, children, whether it is disability, accidents, all of these things that happen in this wonderful journey of life, it's really good to just be aware of it and to understand these risks. So thank you so much, Lara and Esme, for sharing all of that. And for anybody tuning in now on the replay, if you do have any questions, feel free to reach out to myself, Lara, or Esme directly, and we'll be happy to point you in the right direction. So thank you so much, ladies.
Pleasure.
Thank
you.
Thank you. See you later. Bye-bye.
Bye.